Good morning. Today I am taking the presentation on topic dowry death. According to section 304B, dowry death, where the death of the woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry, which deal with shall be called dowry death, and shall husband and such husband or relative shall be deemed to have caused her death. Dowry is defined under Section 2 of Dowry Prohibition Act 1961. Dowry means any property or valuable security given or agreed to be given either directly or indirectly by one party to a marriage to other party to the marriage, or by the parents of either party to a marriage, or by any other person to either party to the marriage or to any other person. The ancient marriage rites of the Vedic period are associated with the Kanyadan. It's later on in the Dharmashastra that the meritorious act of the Kanyadan is not complete till the bridegroom was given a dakshina. So when a bride is given over to the bridegroom, he has to give something in cash or kind which constitute varadakshina. Today, dowry has become a widespread evil and social movements and biggest problem faced by the woman. Marriage is becoming a big source of exploitation and of getting rich overnight in some communities. The spread of education has not helped in curbing the social evil of the dowry. The more highly educated in the young man, higher are the demands of the dowry. The dowry system is one of the prior causes of the family infanticide and fratricide in the India. Domestic violence is another consequence of the evil. Indian Parliament enacted the Dowry Prohibition Act of 1961 to minimize the evil effects of the dowry. The objective of the act is to prohibit the giving and taking of the dowry. Essentials of the dowry death. The death of the woman shall be caused by burns or bodily injury or otherwise than under normal circumstances. Such a death should have occurred even within 7 years of her marriage. She must have been subjected to cruelty or harassment by her husband or by any relative of her husband. Such cruelty or harassment should be for or in connection with the demand for dowry. Such cruelty or harassment is shown to have been meted out to the woman soon before her death. Dowry related offences under IPC. There are 4 situations when a married woman is subjected to cruelty and harassment leading to the commission. First one is cruelty of a woman by husband or relative, section 9 498 A IPC. Second one is dowry death, 304B IPC. Third one is intentional death of woman, 302 IPC. And last one is abatement of the suicide of woman, 306 IPC. Dowry offences and trial. Dowry offences are non-cognizable, non-compoundable offences and non-bailable offence. Cognizance of the dowry is taken by the magistrate himself or on the basis of FIR or complaint lodged by a parent, other relation of such parent person, recognized welfare institute or organization. We can come to a case law that Ashok Kumar versus State of Haryana. In this case, the deceased and Ashok Kumar were married for 2 years, and the father of the girl has given sufficient dowry at the time of the marriage according to his main desire and capacity, but the mother-in-law and brother-in-law of her were not satisfied on their allegedly harassment and maltreated the deceased and used to give her beatings. They had demanded various things like the refrigerator, television, etc. 1 week prior to the incident, the deceased came to the house of her father, narrated them the whole scenario. She mentioned that her husband wanted to set up a new business for which he required some of the money of like 5,000 rupees. The father could not arrange the same due to the which her mother-in-law and brother-in-law burned the deceased by sprinkling kerosene oil, as a result of which the deceased died. And another case, and the Ashok Kumar, mother-in-law and brother-in-law, were found guilty of the offence punishable under the section 304B of the code, and sentenced the accused to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1,000. While upholding the conviction, the apex court held that since the accused is a young person of 48 years, keeping in view that the facts and circumstances of the case, the court awarded 7 years of rigorous imprisonment. Next case is Venugopal versus State of Karnataka. It is held in 1999. The appellant husband was held liable for dowry death under Section 304B IPC for creating a situation whereby the wife committed suicide within 2 years of marriage. Constant demand of dowry leading to ill treatment, harassment, and torture of the wife at the hands of the husband soon before her death led her to take the extreme death of ending life punishment. According to Section 304B IPC, whoever commits the dowry death shall be punishable with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. Despite protests by the women organization, serious activism, legal amendments, special police cells for women, media support, and heightened awareness of dowry being a crime, the practice continues unabated on massive scale. Despite every stigma, dowry continues to be the signature of the marriage. It is an accepted fact. Dowry is not an easy problem to be eliminated. However, such a social menace can be combated with effective strategic measures that would protect the dowry of the Indian bride and would allow such dowry to be treated as higher exclusive property. Hope everyone has understood my topic. Thank you.